Happy May Day, and what a fantastic turnout to the 2012 May Day dinner. We've got a very special guest tonight who will deliver the May Day oration. The Honourable Michael Kirby is an Australian retired judge, jurist and academic who is a retired Justice of the High Court of Australia. He's also the youngest person ever appointed to the federal judiciary, an avid supporter of the arts, a National Trust Australian Living Treasure, a recipient of both Australia's highest civil honour, the Companion of the Order of Australia, the AC, and the Human Rights Medal. And Michael Kirby is also a recipient of the prestigious International Gruber Prize for Justice, which acknowledged his contribution as an outstanding human being who inspires and enables fundamental shifts in knowledge and culture. The Honourable Michael Kirby is one of Australia's most remarkable jurists and human rights advocates whom we are delighted to present for the May Day oration for 2012. So please welcome the Honourable Michael Kirby.
Thank you very much, Jamie, and thank you, fellow citizens, for being here tonight. I acknowledge the earlier presence of the Premier, which was a great compliment to us all and to me, and I acknowledge the presence of members of the Parliament, senators, members of the House, members of the State Parliament, and members of the Judiciary. It's great to be here with all of you, citizens of Australia. Now, I stand between you and your pudding. You are not getting your dessert until after I have finished. And just to show that this is a place where we send off our delegates to Cuba, I want to tell you I have brought up here with me my own little personal pudding, which in a certain, what shall I say, it was a rather elitist tendency at table 3, where I should mention Jamie is now sitting. We got our own pudding first, and you lot have just got to wait until I've finished. So, and if you'll excuse me at a certain point in this address, when I need refreshment, I'm going to take a little mouthful out of my pudding, but I'll just leave it there so that you'll know the elite table number 3. And you know, Jamie can go on about workers and comrades, but number 3's the one. He's moving away from there. He's moving away from number 3 now. But you can't get away from it, Jamie. You organised this show. You kept telling us this is the most wondrous occasion in the history of Adelaide. You told us 17 times that this is a wonderful occasion. Well, you got to wear it. Number 3 is spoilt. Spoilt. And I was warned by an ashen-faced participant. They looked terribly upset and grave. They said, the speaker last year, very, very intelligent, but he did go on and on and on. What a miserable thing to say. That's what you're going to be saying about me next year. I know, that's what you're going to say. And I mean, he only spoke for an hour. I have an hour and 55 minutes set aside, and there are 420 footnotes in my speech, and you have got to just stay there. No serving of the I will watch, and no one gets the pudding except table number 3. And Jamie did something that hasn't happened to me since December 1974. I never thought it would happen again. But at that occasion, I was welcomed in the Arbitration Commission, my first judicial post. By the way, the data wasn't right. I wasn't the youngest person appointed. That was just a bit of political correctness, trying to change what is on my website. I was the youngest man appointed to federal judicial office because Mary Gaudron was the youngest person. She was... And if you want to know about a really fine Australian and fine woman and fine judge, read the biography of me by A.J. Brown and what happened during the week that Senator Bill Heffernan attacked me. The one judge of the High Court who walked across the corridor to come into my room was Mary Gaudron. Mary Gaudron is a person of great spirit. She was also a person trained in industrial relations, was a judge of the Arbitration Commission, and she is a true stalwart. She was the youngest person appointed. I was merely the youngest man. But on that occasion, when the whole court was hushed and speeches were being made in my honour, and of course I was lapping all this up, the barrister for the minister said, "And we're very, very glad to welcome you because of the great fame of your father, Sir Richard Kirby." And that was all very wonderful and very nice of them to say it, except that my father's name was Donald. See, this is another fact of Jamie. Jamie thinks that if you're a judge, then you're Sir Richard's son. And he said, with a slip of the mind, he said, "We want to welcome Richard Kirby tonight." Well, Jamie, I got to tell you, he's been dead for 27 years, and he wasn't my father. He wasn't my father back in 1974, and he still isn't my father. And I've got a perfectly good... My father died last November. He had all his marbles. And he was a perfectly good father, so thank you very much. I'm Michael Kirby. I know you wanted Richard Kirby, but you got me. So just get used to it. And I'm not going home until I've given my hour and 55 minutes.
25 minutes in.
Well, now, I want to start by acknowledging the traditional owners of the land, and I want to acknowledge three wonderful stalwarts of the Labor movement. Number one is Don Dunstan. Wasn't he a fantastic Premier and a fantastic Australian? A real inspiration to all Australians. And why was that? Well, first of all, he had a beautiful voice. Didn't he have a wonderful voice? You know, he had a presence, he had a beautiful voice, but he was substance. And he was a person who led this state, which had been through a large period of sleepwalking, in order to introduce a lot of new laws. Steele Hall, by the way, was also a very decent and good man. He's the one who said, yes, we've got to have equal rights to vote of equal value. But Don Dunstan, the first laws on consumer protection in Australia, the first laws on environmental protection in Australia, and the first law in Australia to get rid of those hateful criminal laws against gays. And many other things. Don Dunstan was a person of substance, and he led the way in our Commonwealth. That's what federations are supposed to do, but boy, it doesn't happen very often. But so I honour Don. Don is in my memory tonight. Secondly, I want to honour Clyde Cameron, MP, because it was Clyde who appointed me to the Arbitration Commission, my first judicial post. And Clyde said that when he appointed me, he thought he was making his one breach of a fundamental rule, that he was appointing a Tory. That's what he thought. But, and he said he was greatly relieved later when he found that I wasn't a Tory after all. But apart from that slip on Clyde's part, he was another person who got things done. I mean, no point being in politics or in public life just to be there for the official cars and the ceremonies and everybody patting you on the back. You've got to use the brief time to do good for the people, because that's your privilege in public life. And unfortunately, not enough realise that. But these two great Australians, Don Dunstan and Clyde Cameron, certainly did. And thirdly, I want to honour Elliot Johnston QC. Now, Elliot, as you know, Elliot died last August, and there's a very good biography by Penelope de Bell, which I reviewed, a brilliant review in the Australian Bar Review. And what an interesting life he had. A man who was a member of the Communist Party of Australia and who never forsook his ideals. He was honest and open about them, and he was offered the position of Queen's Counsel by Chief Justice John Bray, another great South Australian, and the government of the day wouldn't extend the appointment. In those days it had to come from the government, and when that was known, the Chief Justice withdrew the whole list. He said, if you can't have Elliot, who's there on his merits, we're not going to have any. And to their credit, when the government then offered the position to all the other members on the list, every one of them said no. You've got to have Elliot. And Elliot got it then when there was a change of government. Don Dunstan gave it to him, but it passed through the cabinet of the Dunstan cabinet with quite a lot of dissent. But Elliot proved them all wrong, and he was right. He did his duty fearlessly, and he was a very fine man. And I will have the privilege in August, at the anniversary of his death, to come back to Adelaide for Flinders Law School to give the Elliot Johnston lecture later in the year. So he's another very fine South Australian. You have a disproportionate number of very great Australian leaders, and those three are in my mind tonight. Now, I want to give you just a few stories, because I know I'll settle back and relax and don't worry about the pudding. This is what's coming to you. It's coming. And by the way, wasn't that terrific food tonight? I mean, I go to a lot of... My whole life until I became a vegetarian three years ago has been chicken and 2 veg. And generally it's ghastly. It's a wonder I am still my svelte figure that I am. But that was really terrific. There's no doubt about the Greeks. They really know how to cook, don't they? It was really, really terrific. And the Cypriot Club did us proud tonight. But I'm going to give you, in the hour and 3/4 that's left, just a few snippets from life, with, I hope, a few points, so that you've got to keep alert, and then you can ask a few questions at the end. But keep in mind that every question you ask delays the pudding of everyone else. Now, first of all, I've got to come clean, because, and I'm not coming out of the closet now, but I want to reveal that in my early life I had a communist connection. And I know this because, well, I never thought I'd hear any boos here because of the fact that you're getting in touch with Cuba. My grandmother remarried, and she married the treasurer of the Communist Party of Australia. And his name was Jack Simpson. His actual name was Morris Flynn. He fought at Gallipoli. He was a New Zealander. He fought at Gallipoli, fought on the Somme, won the military medal, was decorated at Buckingham Palace by King George V, and he threw away his medals after the war because of the way the veterans were treated, and he became a communist, and it was his religion. And I used to go to their home. I was then about 10, in Tempe, with the trams going by, and he had on his bookshelves the collected speeches of V.I. Lenin. They were, shall I say, in perfect mint condition. I don't think anybody except me had ever opened them. And I used to look at them for inspiration, and one thing I did like about them was they were very, very long speeches. So that got me in the mood of what I'm going to give you tonight. But, and I was there back in 1951 when the Menzies government introduced and passed the legislation called the Communist Party Dissolution Act. And my Uncle Jack and my grandmother were really worried that he was going to lose his civil liberties. And he actually never believed that Dr. Evatt's challenge in the High Court of Australia would be upheld by the High Court. Never did they think that the running lapdogs of the capitalist classes would strike down the legislation. But by a vote of 5-1, the High Court did. They struck it down, and they said, in what I think is probably one of the greatest decisions of the High Court, they said the laws and powers of the Commonwealth extend to dealing with what people do. What they think and believe in their minds is their business. And you've got plenty of power to deal with what people do as communists, but not with their beliefs. And that decision was then subsequently upheld by the people of Australia when an attempt was made to amend the Constitution in 1951, in September 51, and that attempt failed by a vote of the people. And South Australia voted against the attempt to change the Constitution. And so that was my first experience with the communists. And actually, when I go now to my ASIO file, I often get my ASIO file out and read it. I should think that a lot of people in this audience have got an ASIO file. So don't you start laughing about it. You know you're entitled to get it, and you can just request. It's very informal, very easy. And my ASIO file had an agent. He's named as a paid agent, so that you knew whether it was paid or by the Commonwealth or somebody doing out of their love of humanity. But they went and they interviewed my Auntie Gloria. They had great names in those days, and Auntie Glory said, yes, I do have a nephew, Michael Kirby. He is very brainy, but he's a hopeless conservative. So I think she had me pretty well summed up, actually. It's amazing what you see in those ASIO files. I've also asked recently for my special branch file in New South Wales. You remember these, the ones that Don Dunstan dealt with in this state, to a lot of media criticism at the time, but he was right. And they've refused to give it to me. They say, well, this is against the public interest. So that just makes me all the more determined to get my special branch file. And I should think most of you have had a special branch file on yourselves too. But these were my earliest impressions, growing up with a person for whom the Internationale was the national anthem, the red flag was the great song, and a very fine man. And it made me very cautious about the way sometimes people are demonised. You know, there are evil people in this world, and there are violent and cruel people in this world. And we do need a security service to deal with people who go in and blow people up. But many people who are demonised, especially by the media, are just other citizens with different points of view. And we've always got to be there, as the High Court was in 1951, to defend their rights. When I became a lawyer, I didn't do much industrial work. I was doing all sorts of other work. But one day I was asked to take a brief in the Industrial Commission of New South Wales. I didn't even know where the Industrial Commission of New South Wales was, where it sat. And it actually sat in the old barracks building in Sydney. And so I had to actually be pushed in there by the solicitors trying to get me to do this new case. I'd heard that the brief had been taken away from Jack Sweeney QC, from Neville Rand QC, from Bill Fisher QC, and from all the other barristers down the line, one further down, and ultimately it landed on me. And I was a bit suspicious of that because lawyers know when that happens there are some problems coming with the brief. But I went there and a very fine judge, Justice Shepherd, was sitting there, and I found this was industrial justice. And so I became quite interested in industrial justice and in that work, and that's how subsequently I was appointed by Clyde Cameron to the Arbitration Commission. And a very interesting exercise it was. Mary Gaudron had been a Deputy President of the Commission, as was Elizabeth Evatt and a number of other very fine people that I knew at that time, and it gave us quite a practical insight into the way industrial justice could be obtained through the arbitration system, and it made us, I think, quite understanding of the great idea of an industrial arbitration system. That idea, you'll remember, was promoted in the constitutional conventions by Kingston, the Premier of South Australia, and by Higgins, and they pressed that into the Constitution. Ultimately it got there, and it lasted there as the basis of our industrial relations laws until 2006 in the Work Choices case. Subsequently, I had a very great privilege to get involved in the international sphere of industrial relations through the International Labour Organisation. And I was appointed by the ILO to the Commission on Freedom of Association. And that body sent me with two other judges to South Africa on the brink of the change in South Africa from the de Klerk government to the Mandela government, because South Africa had walked out of the ILO and they wanted to get back in, and they wouldn't be allowed in until they'd got their labour laws into line with the international standards set by the ILO. And I had the privilege of meeting Mr. Mandela in South Africa. By the way, as a footnote, Mandela was a very thoughtful person. He, you'll remember, was prosecuted for treason. And they'd had treason trials in South Africa, and usually they ended up with convictions and execution. And that was what was expected to happen to Nelson Mandela. But at that time, the International Commission of Jurists sent out an Australian, Ted St John QC, later became a federal member of Parliament, and he sat at the back of the court in the treason trial, and it was thought that the presence of the international observers, it didn't stop Mandela being convicted and sent to Robben Island, but it's thought that it did give the judge pause and he didn't sentence him to death, as otherwise might have happened. And so Mandela survived, and that great man was there in South Africa waiting his moment when our commission was there suggesting the changes in labour laws. So these experiences taught me the importance not only of justice in the employment sphere in Australia through the arbitration system, but also internationally. Nowadays, we've all got to think internationally, and my experience with that ILO mission was a very good one and a positive one with a good outcome. And the report which we produced, the Mandela government put into operation in South Africa. It was copied in Namibia, in Lesotho, and it's still in force in South Africa. And fundamentally, it was based on our conciliation and arbitration system on the footing that if you get rational people together and they're forced to sit in a room and try to work it out, often they will work it out. And that was the fundamental notion of the conciliation and arbitration power in our constitution. And when I was on the High Court, in 2006 came the challenge to that system. Now, I'll explain it to you that under the Constitution, the federal parliament is given specific powers to enact laws, and those heads of power are generally given an expansive interpretation, as befits a nation with a parliament that has to do a whole range of things. But there's one qualification, and that is if the power is given subject to a condition, you can't read the condition out of the power, because otherwise part of the Constitution would be made a dead letter. That qualification was held by the High Court repeatedly in cases. One of them was the power relating to the acquisition of property by the Commonwealth. And there's a qualification that the Commonwealth can only acquire property on just terms. And therefore, an attempt to acquire property under other heads of power, under the power relating to corporations or the power relating to external affairs or anything else, can't read out the qualification, because the qualification has to be observed if you are acquiring property. And similarly, the question in the work choices case was, did 100 years of the decisions of the High Court of Australia on the conciliation and arbitration power mean nothing? Could you just bypass the power to make laws with respect to conciliation and arbitration for the prevention and settlement of industrial disputes? Could you bypass that by using the corporation's power? And the majority of the High Court said yes. 100 years they hadn't looked at section 5120. They'd been so focused on section 5135. But in my dissenting opinion, I said, in accordance with the decisions on the acquisition power, that if you have a law which in its character is a law that is dealing with industrial relations, with the prevention and settlement of an industrial dispute, if that's the nature of the law, you have to do it by conciliation or arbitration. You can't use another power to bypass the qualification. You follow? And that was a very orthodox way of thinking. It's what all of my predecessors in the High Court had assumed. All those brilliant men, and they were all men until Mary Gordon, what all those brilliant men had thought for 95 years. And when the case came up to the High Court, the work choices legislation was based fundamentally not on the conciliation and arbitration section, but on the corporation section. And the law was changed to make it based on the fact that the federal law was dealing with corporations. And I said that can't be done because it's an attempt to get around the qualification, that it has to be done through an intermediate independent conciliator or mediator. To me, the requirement, which put a brake on the federal parliament just moving into industrial relations and required that it had to be done through conciliation and arbitration, was a human rights type provision. It was saying, in this country, in this fair country, we don't simply leave it to power in the marketplace, to the power of money or influence or big business or big unions. We require that it come back to a rational person who will try, either by a process of conciliation or arbitration, to secure industrial justice. And so the system, conciliation and arbitration, was to me a very important element. And I can't think that my experience as having been a Deputy President of the Arbitration Commission and my experience as a lawyer was irrelevant. I'd seen how this thing worked. And I'd seen, and I was the only one then, Mary Gordon having left, who had actually been involved in that sort of work and knew how important it sometimes is, where the money and the economics is not necessarily for justice, but you had a rational decision maker who would decide what was the industrial fair solution. That, after all, was the way we secured equal pay for women through industrial awards. And that was in a great case where Mary Gaudron acted for the Commonwealth supporting the provision. It was how we secured the equal pay for Aboriginal stockmen in the Northern Territory. That was also secured through the arbitration system. It was how, in cases I was involved in at the bar, we secured industrial justice for shift workers when the scientific evidence was proved of the circadian rhythms and the way that impacts upon a worker and the way that has to be compensated for in time provisions and also in money. It dealt with all of these issues. This was the way we did it. It was one of our rare legal inventions in Australia and New Zealand that we had. But in 2006, swept away. And now the power of the Commonwealth to deal with industrial affairs by the decision of the High Court of Australia can just proceed directly to Section 5120, deal with it if it's being handled by a corporation, and that's it. No need for conciliation, no need for arbitration. And Section 5135, conciliation arbitration, may as well never have been there. And hundreds of cases in the court that had been considering this for 100 years were worthless. Tear it up, and we're now back just to the marketplace, just to power, just to economics. Well, I think that's a big loss for the Constitution of Australia, but it's what the court has decided, and it's not going to change any time soon. But that brings me to my final point, which is a point relating again to the international sphere. There's a terrific book which I received in the last few days. I've got to be careful I don't look at my pudding. And this is a book on the new developments that are happening in the international sphere, which anybody in the industrial relations field and in the field of workers' rights should be up to date on. The book is called The UN Guiding Principles on Business and Human Rights, and it relates to an endeavour in the international community and in the human rights mechanisms of the United Nations to make provisions to make corporations answerable to human rights standards. At the moment, human rights standards are imposed upon states, nations, but in the last 20 years there's been a move to try to make corporations answerable to international human rights standards. And why should that be so? Well, the answer is very clear. Now, transnational corporations are often much bigger than most of the states of the world in terms of the economy, in terms of the money, in terms of the population dependent on them, in terms of the power. Many transnational corporations are extremely powerful, and they're not always human rights respecting. Some of them are human rights disrespecting in the way in which they employ workers and pay workers. You will have seen the advertisements and material on, say, those workers underpaid virtual slave labour who collect the chocolate beans, the cocoa beans, which are used in the chocolates we all eat. That's one way. And the second way is that retailers, big retailers, are not taking steps to ensure that they don't buy and promote and sell products that have been produced by this slave labour. And that's why back in the year 1998, the international community started to work towards principles binding on corporations and saying states and individuals are responsible for the human rights principles, but so are corporations, including multinational corporations. But that was proposed in 1998, and it led to a tremendous upcry. The usual suspects attacked it, and the Human Rights Commission, as it was then, said, well, we're not going down that track. We're not going to impose human rights obligations on corporations. And instead they asked an Under-Secretary General of the United Nations, Professor Ruggie, a Canadian, to come up with another set of principles, and he came up with some very soft guidelines which are not along the lines of a treaty which would be binding on transnational corporations, and they are the guidelines that are now in place. Rather soft, rather gentle, and not likely to be very powerful in dealing with opinionated international corporations. And if you look at the situation of corporations in the world today, this is what a professor in Sydney said. It's worth reading you this, because I'm now giving you, this is breaking news. This is what you've got to start thinking about if you're in the field of industrial relations and workers' rights and the rights of ordinary individuals. The work to develop the framework which Professor Ruggie has proposed, governing human rights aspects of business, together with its operational guiding principles, has coincided with one of the worst financial crises to hit the global economy and financial systems in many decades. The social and individual welfare impacts have been wide-ranging and devastating. Estimates suggest that over 27 million workers have lost their jobs. The number of people in vulnerable employment has risen to 1.5 billion. 64 million more people are living in extreme poverty, and over 1 billion people, or 1/6 of humanity, are now undernourished. Flowing from these circumstances, a raft of human rights have been threatened or undermined, including the right to food, to water and to an adequate standard of living, to health, education and adequate housing, to non-discrimination, to privacy, to bodily integrity and to a fair trial. The poor are often at the margins or effectively excluded from the rule of law processes, as well as health and safety in workplace and the right to work itself. In the advanced economies, the socialisation of financial sector losses through state bailouts has in some cases tripled the debt burden on states, leading to sovereign debt problems and savage budget cuts that could undermine individual human rights enjoyment. The impact of the crisis on the USA economy has raised the deficit to a level not seen since 1945 that has pushed that country close to defaulting on its debts of US dollars 14.3 trillion. European governments are also projected to make hundreds of billions of dollars worth of spending cuts over the next 4 years and will directly impact public service, employment and pensions, all of which are closely aligned with these states' obligations under international human rights law, in particular the International Covenant on Economic, Social and Cultural Rights. And the point that the authors make is that these impacts on the global financial crisis isn't just some figment in banks which is dealing with billions of dollars, though it is that. These are things that fall on ordinary folks in their homes and in their capacity to eat, to clothe, to house, to educate their children and so on. So this is a very big issue for fundamental human rights. And if we don't have a means by which transnational corporations, which are the instruments by which many of these decisions are made, subject to the principles of human rights, but only to some soft guidelines, then we really are setting back the course of the human rights protection for all of humanity. And that's the most important thing I've come to tell you tonight. It's very important that those who are seriously in this area should keep their eye on internationalism, because that's the flavour of the age, but also on the issues of fundamental human rights, and particularly the struggle in the UN human rights machinery between those who wanted to have a treaty binding on transnational corporations with binding legal obligations to which they could be held, and those who caused such a fuss that that was withdrawn, and now they have very soft guidelines which fall far short of that. So it's a very important question, and particularly at the present time. Now that only leaves me one very last thing to say before you all can get let loose on your pudding, and that is this. I've also brought another absolutely outstanding book. It's a book by myself. It's called Michael Kirby, A Private Life. Did you know this book is up in the next 2 weeks for multiple awards? It has been praised to the skies. It is now a must-have book. If you haven't bought it yet, then you'll regret it if you don't get it soon. And it's going to win prizes as the most readable, wonderful book. If not of the year, then of the decade or perhaps of the century so far. My hope is that this book, selling for a miserable $35 and discounted in some stores, that this book is going to outsell Lazarus Rising. And that won't happen. No good clapping. No good clapping. You've got to dig into your pockets and you've got to buy it. And that, I don't think that Senator Don Farrell should read this because I better drop my voice now. It does refer to my relationship of 43 years with my partner, Johan, and we wouldn't want to shock the good senator. I was hoping he'd turn up tonight. He usually turns up for May Day, but he saw who the speaker was and didn't turn up because I was going to ask him, what have we done to the shop assistants that they hate us so much? Why do they hate gays? Anyway, some of his colleagues in the Senate who are here tonight can perhaps ask him and send me an email. I'd be very interested to know. And I'd be very interested to know how a relationship of love, of trust, of kindness, of gentleness, of being there, of telling you when you go too far, of giving you the truth, and of touching, of feeling, of kindness, of outreach, loved by family, loved by friends, loved by me, how that in any way threatens the love and relationship of straight people. I don't believe it. I don't believe it. And we in Australia, back in the days when we introduced conciliation and arbitration into our law and gave women the right to vote, South Australia was the first jurisdiction in the world that gave women the right to vote and the right to stand for Parliament. Both things, right to vote and the right to stand. South Australia. You used to be so innovative. We in Australia used to be so innovative. We are not innovative anymore. We are a frightened and hesitant and negative country, and we've got to get over it, and we've got to change things. We've got to get back to the original fair go for all. Okay, that's it. You're putting your weights, but I think, Jamie, are you going to come up here and are you going to allow any questions?
Well, seeing as Richard took so long.
That's all right, Peter.
The Honourable Michael Kirby said he would take a few questions, so do we have any? Don't all put your hand up at once. Comrade?
and directors, and indeed override state legislation or state powers with respect to the control, the allocation of water rights in the states, in the Murray-Darling Basin.
Thanks, Ralph.
I can smell a real live case in that question. You know, I left, when I left the High Court, I went out of the business of solving difficult legal problems. And not only that, but I don't have a practicing certificate, and if I tried to do so, there's sure to be a lawyer in this audience who'd dob me in. So I don't think I'm really empowered to answer. It sounds like a legal question to me, and I think I'll leave that to those who have the responsibility now to decide it. But generally there's power if you search hard enough in the interstices of the Constitution. And, but I think that's something which will probably come before the High Court. So if you'll forgive me, I'll stay out of that. Yes.
Michael Latz first, sorry.
My question's about David Cameron's Big Society.
About?
David Cameron's Big Society.
Oh, yes.
Over in the UK, where essentially cuts to public service have led to outsourcing of services that are normally traditionally run by governments, which has seen a huge default to the number of charities, creating huge vulnerability for those charities. Broadly, quite a lot of chaos and not so much a good outcome for our workers over in the UK. I just wondering if you had any thoughts on what was going on with that and what that looks like.
Well, that was all on the news when I was over there last week in the UK, and I'm always suspicious when a politician comes up with an idea, the big society. I thought President Lyndon Baines Johnson had the big society, or I think he got there first. And in fact, we have to say that, you know, though LBJ did some pretty terrible things in Vietnam, it was he who got through the Civil Rights Act as a result of the assassination of John F. Kennedy. But I don't know the ins and outs of the English charities law. I do know there's a very hot issue which is in our own country, which is going to be before the budget cabinet of the federal government in the next few days, closer to home, which concerns whether the twice repeated commitment of government, which also, I should say, had the support of the opposition, that we would move in our foreign aid up to 5% of GDP, whether that promise is going to be kept or whether, with an excuse of the economic situation, it's going to be backpedalled on. So watch that space. But one thing that David Cameron said in the context of his so-called big society, which I rather liked, was this. He said, when a few of the more conservative troglodytes in the Conservative Party in the United Kingdom started giving trouble. They were sort of like the other senator from South Australia, and they were causing all sorts of trouble. And he said, I want to make it clear that I am supporting marriage equality, not despite the fact that I'm conservative, but because I'm a conservative, because it is in the interests of society to support responsibility and commitment. And that is a position which I'm quite comfortable as a Conservative to adopt. I've been listening again. I put my ear trumpet on to hear, but I haven't heard anybody on the Conservative side of politics, which means the coalition parties and some members of the Labor Party. I haven't heard any of them say the same thing. And I think on that matter, I don't know what his position on charities and so on is correct, but he's certainly on the right track there, in my humble opinion. It is in the interests of society. It's in the interests of health. There is very well established material that if you have a stable personal relationship of love, trust and support, that is good for your psychic and your physical health. And by what right to some people on the basis of their religion in a secular country deny other citizens that entitlement. It is unacceptable. Unacceptable. One more question.
Only one more question.
Yes.
Hang on. Oh, there's two.
Oh,
He's
we'll
had his hand up for a while.
yeah, okay. Michael's
Michael,
had his hand. You get a sort of half a question and one question for the lady at the end there. Okay.
I'll push my luck there. Most of the people in this room, probably all of them, spend a lot of their time trying to stand up for people, usually workers, who are at a pretty serious disadvantage, and they might roll up and there's a room full of executives or the advocates here, there's 3 or 4 lawyers in a silk and all the rest of them, it's someone who's been out of law school for 2 years. Two things. Someone in this room told me in my early days, I don't know if the Latin's right, you'll know where it's wrong. Nil corporandum illegitimates, don't let the bastards grind you down. What would you say to help people stick to that? And for the advocates in this room, when you're faced with the David and Goliath, what would you tell them?
Non corporandum illegitimum. Well, you see, I never had a problem with that. First of all, it isn't always the case that the poor little worker, you know, I've got to get out my hanky now and have a little sob about your story and your mental picture, because in my day anyway, often the better lawyers were down the other end for the workers. The better lawyers, because they not only had the intellectual commitment, but they had the moral commitment for what they thought was a just cause. Also, I never had a problem with that because my ethnicity was Irish. Northern Irish, but it was still Irish. That's the big secret about Ireland. They're both the same, north and south. They're both very difficult people, and when they think that it's a matter of justice, that just fires them up to do better and to work harder, work their butts off. That's what I did when I was a young lawyer. So my advice would be, don't worry about it. Do your best. Work your guts out. Make sure you do what the client would do if the client had the talent, experience and training. And don't be off-put by those silks. Often, they've been drinking too much port the night before and they don't know enough about it that you can know if you really work your guts out. That was always my thesis in life. You know, people could disagree with me, but I never gave them space to be critical of the fact that I was in any way inferior or not as well prepared. I was always better prepared. I still am always better prepared. Think of this speech I've given you tonight. Magnificent. Now, one
It's gone for an hour and 55.
Oh, you keep quiet there, Andrew. I can't hear this. What is she saying? Well, I didn't hear all of that, so I'll have to ask Alexander what you said there.
Well, George.
She was just asking about whether the fear of being propagated around the world at the moment, because social media can play a role in sort of fixing that.
Yeah, well, I think there are many issues presented by the social media, and you know, I went overseas for a week and a half, and I came back to 4,000 emails. I got in off QF24 at 9 o'clock. I was in my office at 10 o'clock and I worked until 1:30 a.m. the next morning answering those emails. I mean, this is the world we live in. That's not social media, that's just media. And the fact that social media presents the persona of the person, and that young people feel obligated to tell everything, not realising that potentially that's going to be there forever and going to haunt them later on When they want jobs, it's going to be checked. When they have personal relationships, it's going to be checked. It's going to be a great source of material for lawyers in court cases, as is the email trial. You know, many murderers today are caught by the email trial. That's probably a good thing. But the revelations of the privacy of the individual in the social media is a big worry, as I think is the fact that people today, even in their family home, will be texting each other, members of the family, and will not be having an actual real live conversation. I mean, this is a big worry. Wasn't I lucky to live in a family where we all sat down at the table, where we only got black and white television at those days when the exams were finished? We all talked with each other. And we are still so close because we found that we weren't bad people, actually, and we love each other. Whereas nowadays, it's an intermediary of this technology that is leading to a distance, and I think it's not going to go away. You and I are not going to be able to wish it away, and it has many great advantages. With YouTube, for example, you can go into YouTube and you can see the wonderful performances of the greatest operas and the greatest singers. And so there's so much there that is useful. But the question is the information overload and the fact that we're all being swamped by it, and I'm swamped by it, and that young people are revealing aspects of themselves whilst they're still developing. There are lots of problems here, and there's a great need for law reform and for action, but not for the censors. We can put them out to pasture, but we do need to protect young people from themselves sometimes. Well, as Jamie said, this has been a terrific dinner. You've been a wonderful audience. I'm very respectful to you. I'm respectful for those who stand up for the rights of fellow citizens and stand up for their own rights. And that's what we all should do in a free Australia. And that's what South Australians have always, or almost always, done, and it's a good thing. And I do hope you won't forget the little advertisement that I've loaded in there.
Can you all thank the Honourable Michael Kirby?